Okay, so now you're live on YouTube as well.
Okay, and we only have those people.
Yes. Do you want to go ahead and admit?
Admit, yeah, admit the
Gafford?
defendant,
Okay.
and I guess he's the officer. Anybody else? Is Kevin admitted?
There's two of them. I don't know why.
Okay, let me see if,
And my witness just got on there, Judge.
Okay, Greg, so are all your witnesses here?
It looks like Josh Gafford is my only witness. Looks like he just showed up.
Okay, good. Let me unmute Mr. Rosales. Mr. Rosales,
Yes, sir, I'm here.
can you hear me?
Yes, sir, I can.
Okay. Sir, do you have any witnesses?
I do not.
Okay. So we have one witness and Mr. Connor's here. Mr. Rosales is here. Okay. Before we get started, let me take up some pretrial matters that I just noticed. Mr. Connor,
Yes.
can you take a look at the complaint, please? Look at the bottom at the notary.
And it was filed yesterday.
Right. The original that was filed was not notarized.
Okay, I'm just seeing that it was stamped for the record on March 8th.
Right. It was because it was filed and we stamped it, but it was signed by Ella M. Reina, and then there's no notary date, nor a notary signature.
Judge, we never have those on these.
Yeah. And this is the first time that I've noticed that it wasn't.
No, I mean, the legality of it is once it's filed with your office and stamped received.
Nobody notarized the signature. It is received, but nobody notarized the signature.
Okay.
So let me tell you where that puts us. Mr. Rosales, you're entitled, if you ask, you're entitled to have 1 day notice of a copy of the complaint. The complaint is the formal charging instrument against you, okay? And so we can do a couple of things here. Number one is you can waive the requirement. I don't know if you can see it. You can waive the requirement of the state notarizing the affiant signature. Okay, and we can proceed with this case, or if you don't want to waive it, and then the state can amend and refile their complaint, get you a copy, and we can reschedule the hearing. You're here already, so it's up to you.
I think I'll go ahead and elect to waive the
And
notary.
just proceed.
Yes, sir.
Okay, Mr. Connor, and then if he's waiving the requirement of the complaint being notarized, then we can proceed with this.
Okay, Judge, are we on the record right now, just for the record?
We're on Zoom, and we are on the record now.
Okay, because I'm reading chapter Article 45019. And I am not seeing anywhere, like I said, we have always done it that way and we've never notarized, and I'm not seeing that requirement. So I just want that for the record in case there's an appeal.
Okay, and that's fine. Mr. Rosales has waived that requirement anyway, so we will proceed with this case with the file mark complaint that's of record. So before we go any further, is there a video in this case?
There is, Judge.
Was it made available to Mr. Rosales?
I do not have that because I do not have a physical file. I don't know if he came and watched it.
Okay, Mr. Rosales, did you ask to watch the video?
I did, which I was told that I would have to file a legal motion in order to gain access to the video.
And did you
And
file it?
Judge, that was not told that he would have to file a written. That was in order for him to get a copy of it. He was explained that he could come down here and watch the video.
Okay, so Mr. Rosales, did you have a chance to watch the video?
I have not had the chance to watch the video, Your Honor.
Okay. And the video was made available to you according to what Mr. Connor has just told the court. And is that your understanding also?
Yes, Your Honor. They did mention that I would have an opportunity to go by one of the days, but I was just unable to due to the to law school and due to working part-time.
Okay, but it was made available to you, okay?
Yes, sir.
Okay, and that's what I needed to know. Well, the record's going to reflect that a video was preserved and made available for defendant to view, and that defendant was not able to go and view the video. Is that your understanding, Mr. Rosales?
Yes, sir.
Okay, thank you. So a couple of more things is, so that takes care of the discovery acknowledgement. Mr. Rosales, when you set this case up for trial, you understood that you had a right to a jury trial, correct?
Yes, sir, I did.
But you elected to waive your right to a jury trial and have your case heard by a judge and have a non-jury trial, correct, sir?
Yes, sir, that's correct.
Okay, let me also explain to you that you have a right to counsel. You have a right to be represented by an attorney in this case. Since the maximum penalty in this case does not include time in jail, you do not have a right under the law, neither the Texas nor the United States Constitution, to have an attorney appointed. You have the important right to hire legal counsel. An attorney can advise you and help you make important decisions concerning the consequences and alternatives in this case. An attorney is familiar with trial procedures and the rules of evidence. In this trial, you will be held to the same legal standard as if you were an attorney. Do you still wish to proceed representing yourself, sir?
Yes, Your Honor, I wish to.
Okay, thank you. Lastly, let me just explain your privilege against self-incrimination. You are not required to testify, and no one may make you testify. If you decide not to testify, I will not use the fact that you did not testify as evidence against you. Choosing to remain silent cannot be used against you. Do you understand that, Mr. Rosales?
Yes, sir, I do.
Okay, thank you. So at this time, let me call the case. This is cause number 2103060, styled State of Texas versus Kevin Rosales. What says the state?
Present ready.
Okay, Mr. Rosales, you are present by Zoom, and are you ready to proceed, sir?
Yes, sir, ready.
Okay, thank you. So at this time, Mr. Connor, let me have a reading of the complaint, please.
In the name and by the authority of the state of Texas, I, the undersigned affiant, do solemnly swear that I have good reason to believe and do believe that one, Kevin Rosales, on or about the 25th day of January, 2021, before the making and filing this complaint within the corporate limits of the city of Lubbock and Lubbock County, Texas, did then and there drive a motor vehicle upon a public street, to wit, at or about the 4900 block of North Loop 289 Access Road, at a speed of 61 miles per hour, a speed greater than is reasonable and prudent under the conditions and circumstances then existing, at which time and place the lawful maximum prima facie reasonable and prudent speed indicated by an official sign then and there lawfully posted was 45 miles per hour. Contrary to the laws of the state of Texas and the city of Lubbock, Texas, my belief in the aforesaid statement is based upon the information provided to me by Joshua Gafford, a peace officer of the state of Texas who personally observed or investigated such offense against the peace and dignity of the state signed by Ella M. Reyna, affiant, sworn to and subscribed before me on the 8th day of March, 2021. My signature as the Assistant City Attorney for the Municipal Court, City of Lubbock, Lubbock County, Texas.
Okay, also for the record, I would like it to reflect that the original that was filed of record yesterday on March the 8th of 2021 does not include the signature by the Assistant City Attorney, nor does it include the date that it was notarized. But the defendant has waived.
Judge, I do now. I did not understand what we were talking about in pretrial, but the copy I have now has my signature in that. I think that was a mix-up in the procedure, but I think you should have a copy of the one that is notarized.
Let me check the file, because the one that was file marked yesterday is not notarized at all. Let me just check. No.
Do you mind if I step out for 1 second, Judge? We're
okay.
good. We're good right now. We'll just
It's
go
up
ahead.
to you. Do you want a couple of minutes?
Yeah, if you'll give me a minute, I'll be good.
Okay, that's fine.
Judge,
Yes.
I'm told Janet has it, that there was a mix-up because there were 2 copies out there, but Janet does have the signed copy because that's where we got our copy from.
Okay, I will check with Janet later on, but again, it's a moot issue because Mr. Rosales has decided to waive it anyway and proceed on with this proceeding. Is that correct, Mr. Rosales? Mr. Rosales?
I'm sorry, I was muted. Yes, Your Honor. That is
Okay,
correct.
thank you. Okay, so we will proceed anyway. And so now, Mr. Connor, opening statement?
We'll waive, Judge.
Okay, Mr. Rosales, the state has waived their opening statement. You are still entitled to make an opening statement if you so wish to do. However, since the state has waived it, you can make your opening statement once the state rests, and I'll let you know when that is. Is that okay with you, sir?
Yes, Your Honor.
Okay, thank you. So, Mr. Connor, if you can please call your first witness.
State would call Joshua Gafford.
Okay, Joshua.
Yes, sir. Can you hear me?
Yes, I can. Let me just swear you in here in a minute. If you can please raise your right hand.
Let me see. There we go. All
Okay.
right.
Mr. Rosales, are you unmuted? I just want to make sure.
Yes, sir, I am.
Okay, thank you. So, Officer Gafford,
Yes, sir.
do you solemnly swear or affirm that the testimony that you're about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, thank you. Mr. Connor, you may proceed.
Thank you, Your Honor. Will you state your name for the record, please?
Officer Joshua Gafford,
And how are you employed, sir?
Lubbock Police Department.
And how long have you been so employed?
A little over 11 years.
And what is your present duty assignment, sir?
I'm assigned to the traffic division on the motorcycles.
And as that assignment, what are your primary duties?
Traffic enforcement and funeral escorts.
Okay. Were you a certified police officer on the 25th day of January, 2021?
Yes, I was.
And were you assigned, as you said, to the traffic unit?
Yes.
And were you on duty on that day?
Yes, sir.
Okay. Did you have occasion on that day to come in contact with a gentleman by the name of Kevin Rosales?
Yes.
And this is kind of different being on Zoom, but do you see Mr. Rosales in the virtual courtroom?
Yes, I do.
And can you identify him by something he's wearing? I mean, his name's on there. I guess you could say his name is on there or whatever. Is that the gentleman that you came into contact?
Yes.
Your Honor, we would ask that the record reflect that the witness has identified the defendant at this time.
The record will so reflect. You may continue.
And where was it, sir, that you came into contact with Mr. Rosales?
And approximately the 4900 block of North Loop Access Road.
Okay. And is that located in any city,
Yes, Lubbock,
in any state,
Texas.
and any county?
Lubbock.
And is that a public place?
Yes.
Now, what was the occasion of coming into contact with, what was your occasion to come into contact with Mr. Rosales?
I observed Mr. Rosales speeding in that location.
Okay. And is there a posted speed limit there?
Yes.
And how much is it posted?
45.
And where is it posted at?
It's posted from where I was parked at approximately 800 feet and at that point to my left, so it'd be to the west. And there's a sign on either side of the road.
And that's shortly after you come off of the loop. Is that correct?
Correct.
Okay. Now, what kind of area is it that is located in? Residential, business? What is it like?
Residential.
So is going 65, or correction, going 61 in a 45-mile-an-hour zone there, is that reasonable and prudent?
No.
And what do you base that on?
I base that on the fact that the speed limit is posted at 45 and 60 is excessive.
And I may have spoke ahead of myself, but what did you measure his speed at?
61 miles per hour.
Now, how did you measure his speed?
I used my laser.
Okay. Now, for the benefit of the record and of court, what is a laser?
Lasers, what we use to calculate the speed from the vehicle from a moving object. Basically, it calculates the time and the distance for the laser emitted from my device to reflect from the vehicle back to me, and it calculates the speed.
Okay. And it shoots a beam, is that correct?
Correct.
Now, are you certified to use this laser?
Yes.
And how are you certified to use it?
I was trained in the academy and then recertified
Okay.
2 years ago.
And have you used this laser on few or many occasions to testify in this court or other courts?
Many cases.
Now, there's checks and balances with your laser, correct? I mean, how do you check it to make sure that it's working right?
We test them usually every time that I replace the batteries. I test them to make sure that it is functioning properly.
Okay. And when you say you check to make sure it's functioning properly, how do you do that?
We have an actual test that you do. You've got your sight and sound test. You've got the display screen test in the back. You've also got a tone test that tests your alignment.
And you say you test this every time you change your battery, correct?
Correct.
Approximately how often is that?
It's usually, depending on the amount of use, probably every 2 weeks.
Okay. So if for some reason, has your laser ever malfunctioned?
No.
If for some reason it did test on a malfunction, what would you do with the prior citations for that week?
Well, if it did show up an error, it won't work at all. It'll just display error. So I wouldn't even be able to use it to test.
Okay. Well, what I'm getting at is everything set up for the benefit of the offender. Is that correct?
Correct.
So wouldn't it be reasonable to say that if your laser malfunctioned, you'd probably dismiss the citations prior to?
Correct.
Okay. Judge, at this time, we would ask that the court take judicial notice of the Dallas County case, which goes to the validity and the reliability of the laser mechanism as far as measuring speed.
Okay, the court will take judicial notice of that, and you may continue.
Okay. Officer Gafford, I believe you testified that from where you sat, it was approximately 800 feet to the signs. Is that correct?
Correct.
And I believe you said that the signs are at the end of where you merge or where you get off of the loop onto the access road, correct?
Correct.
And in your opinion, sir, is there a reasonable amount of time from when you get off the loop to when you get to those signs to be slowed down to 45 miles an hour?
Yes.
Now, you said it was 800 feet to where you measured from the signs, but how far away were you from Mr. Rosales when you measured his speed?
321 feet.
So that's approximately 500, if not more, feet past the signs. Is that correct?
Correct.
And a city block's roughly 400 feet. Is that correct?
Correct.
So it was more than a city block. He was still going 61 miles an hour in a 45 mile an hour zone, correct?
Correct.
Now, I don't have a copy of the citation here with me, but what kind of vehicle was it that Mr. Rosales was driving?
It was a 2015 blue Subaru Outback.
Okay. Any doubt in your mind when you measured that speed that it was Mr. Rosales' vehicle that you had got?
No.
Sir, when you were working traffic that day, were you equipped with anything capable of measuring audio or video recordings?
Yes, my body camera.
Okay, and we're using it that day.
Yes.
And are you competent in using that?
Yes.
Have you observed the video that was made during that time of the traffic stop as it happened that day?
Yes.
Has it been altered in any way?
No.
Your Honor, at this time, the state would offer State's Exhibit 1 being the audio and video that was recorded by Officer Gafford at the time of the stop.
Okay. Mr. Rosales, do you have any objection to State's Exhibit 1 being introduced or being admitted rather into evidence?
No, Your Honor, I do not.
Okay, so State's Exhibit 1 is admitted into evidence. And Mr. Connor?
Your Honor, I would ask to publish now.
Okay.
And
go ahead.
and bear with me because this is the first time that I've done it this way, but we're going to try to publish this video.
Okay, let's go ahead and try it because this is a first for all of us, being that it's
Okay, Judge, I'm getting a message that says that the host has disabled participant screen sharing.
Okay, let me enable it again. Okay.
We learn together, Mr.
Yes,
Rosales.
we are. Bear with us, Mr. Rosales.
Try now.
Try now.
All right, let's see here. No.
And I apologize, Amanda.
No, you're fine, Judge. As long as I have mine.
No, that's okay. Thank you.
Let's see, I've got sharing options. Yeah. You can start sharing. It says he should be able to.
Okay, let us know you're able to.
I'm trying right now. I'm seeing, let's see. All right, let's see what we got here. Are you seeing my screen there, Judge?
Oh, yes.
We are.
Yes.
Yes, we are.
He was doing it.
Okay. Is Mr. Rosales still on?
Yes, sir, I'm still here.
Okay.
All right. Here it is, Judge.
Okay. Go ahead and publish it. I'll call you if I need.
Don't leave, right? Just
Don't-
stay here.
Yeah, because
Okay.
why aren't we seeing anything?
Should just be seeing his screen. Greg,
What do you want me to ask?
Judge, I don't know if y'all caught, it skipped a little bit there. I'm going to try to start it over.
I haven't
No.
seen anything, Greg. Mr. Rosales?
is it just audio, Greg?
Nothing seems to be showing.
No,
All I
it's a
see is
video.
on a Zoom.
Okay, we haven't been able to see it.
It just shows the Zoom.
Can you see it now?
Oh,
Yes, now we can. Okay.
Were you able to see that?
Can you start it again, please? Because it just came on my screen. Mr. Rosales, can you see it?
At this moment, I can, yes, sir.
Okay, thank you. I want to make sure.
Judge, technical difficulties. I don't know why it is jumping right there.
It seems to be. See if she can bring it up to you.
Judge, I have one other way to play this. Stand by.
Okay.
I apologize, Mr. Rosales. You know how technology is.
Mr. Rosales is young enough to make sure it doesn't work this way. We're the old ones.
Yeah, I'm a little more experienced, but you can figure it out sometimes.
We will.
Well,
Just give
we
us
made
time.
a test. We made a test run yesterday and everything was perfect, but you know, you let time go there. Let's see. Officer Gafford, what time was this ticket?
12:40 on the 25th.
12:40.
Yes, sir.
What's your employee number, Josh?
139282.
All right, here we go.
Officer Gafford, let the police department.
Yes, sir. I was exiting the freeway. I was hostage.
Whenever you exit the freeway, you gotta be at 45 mile an hour by the time you get to the end of the ramp where that speed limit sign is.
Okay.
Okay?
Well, yes, sir. Could you give me a chance, my chance? Let me get my.
So far, thank you. What were you saying?
I was gonna say, he can give you a chance. I was trying to slow it down.
Like I say, you gotta be at 45 by the time you get to that speed limit sign. Address, everything's still correct on it?
Yes, sir. Is there anyone to give you a warning, sir? I was just trying to slow down naturally, and I know you're right at the spot where the exit's at, so.
Actually,
I'm using a safe drive.
right, where I set at, right there at North Troy, is about 800 feet from where the 45 speed limit signs.
Yes, sir.
Okay?
Yes, sir.
And just a second, I'll tell you exactly how far. Look, just 321 feet away from me. Okay, so you're already 500 feet past the speed limit sign. All right? Okay. Hang on. Okay, sorry. I just don't like having something else in my hand.
Yeah, you're good. Would you mind give me a warning by chance? I know I'm a safe driver. I haven't taken a while.
Greg, it's a bad video. I can't make out most of what they're saying.
Well,
Okay, Judge, we've entered it and I will get you what we've entered.
Okay, can you get me, provide me a hard copy?
Yes.
Okay, thank you. Go ahead and proceed.
Officer Gafford, you saw, we had some problems buffering there, but you kind of saw that video, correct?
Yes, sir.
And you had explained kind of what testimony was prior, that it was 300 feet from you, correct, or give or take?
Correct. 321 feet.
So there had been more than a block passed prior to you measuring a speed on a 45-mile-an-hour zone?
Yes.
And again, no doubt that it was Mr. Rosales or Mr. Rosales' vehicle?
Correct. No doubt.
Pass a witness, Judge.
Okay. Mr. Rosales, cross-exam. You're muted, Mr. Rosales.
I always forget to do that. Sorry, Your Honor.
Don't worry. Your turn to, if you want to question the witness.
Yes, I do. Officer Gafford, I hope you're having a good day. I did have a few questions in regards to what happened that day. Do you remember what cross intersecting street you're at the moment when you were stationed using your radar? Direct exit?
200 North Troy.
200 North Troy, that's right. And you said you clocked me in at about 300 meters after the 45 mile per hour speed limit.
321 feet, not meters.
Okay, feet. Okay, perfect. All right, good to know. Furthermore, one moment. Now, is it to your belief that you clocked me after I crossed the 45 mile per hour sign?
Yes.
You're completely confident in that testimony?
Yes.
Okay. At what time did you initiate using your radar directing towards me?
It wasn't a radar, it was a laser.
Yes.
They function differently. And once I observed you coming off of the loop, that's when I started lasering your vehicle, and I continued following your vehicle all the way until you had come to the point where I decided to go ahead and initiate the traffic stop.
I see. So due to the fact that you started labeling my vehicle with your laser, so you said it was at the moment of exit or beforehand?
It was after the exits, whenever I initiated the traffic stop. So before, I was just continuing to follow your vehicle. And because from where I sit, I also monitor the loop, because I'll catch people up there on the loop doing excess of 80 mile an hour, and I can go down and get on the on-ramp and stop them if need be.
Okay, so you were just keeping an eye on my vehicle until you actually made the determination that I was speeding.
Correct.
So is there any chance possibly that the number you recorded at the moment that I crossed the 45 mile per hour sign may have been the number that was indicated before I got to that sign?
No.
There is not.
No, because it reads every, I can't remember exact 100th of a second, I believe, but it's every second at least. It continues to give me your speed. So whenever you were doing 70 on the loop, I could follow it 69, 68, 67 as you continue to slow down. And once you were past the speed limit signs, that's whenever I determined that you were doing 61 in the 45. And that's when I decided to initiate the traffic stop and make contact with you.
Okay, I understand that. Okay, I have another question. So obviously, I mean, you're obviously a trained officer, having been in the force for over 11 years. Now, do you ever have trouble maintaining a stable hand to be able to cross, signal, not necessarily cross, to be able to record the vehicle with a laser, to be able to access it? Do you ever have trouble trying to keep your hand and the laser on the vehicle?
No.
No?
Usually, with the way that I set on the vehicle, I'll usually lay the laser to where I can hold it. And sometimes I'll rest my elbow to make sure that I can maintain steady contact.
Okay, I see. I see. Now, now you mentioned earlier, do you remember the speeds that I was traveling before I entered the access room? Because I remember you saying that you were aiming at me before I got there.
Correct. You were doing 70 mile an hour and you were slowing down. And once you got past the end of the off ramp is whenever I continued to laser. And like I say, that's when I determined to make the stop.
Now, do you remember if there are any other vehicles near me at the moment while I was about to exit?
No, there was no more vehicles.
Okay, it's your testimony that there's no more vehicles. Okay. Would it be possible, due to the fact that you had your laser on me, that you may have missed another vehicle that was traveling nearby me?
Negative.
Okay, it's not possible.
No,
All right.
my laser at 1,000 feet, the beam on it is only 3 feet wide. And if you're less than 1,000 feet, that beam's even smaller. So being that you were less than 500 feet away from me, that beam's only 18 inches wide, and the front end of your vehicle is probably approximately, if I'm going to guess, 6 feet wide. So for me to be possibly trying to get another car or another vehicle, I would have to be significantly off one way or the other.
Okay, so you mentioned that the basic radius of the laser is 3 feet wide at 1,000 feet, right?
Correct.
Okay, so would it be possible, due to the distance between the ramp and from where you were standing, that you may have contacted another vehicle because it was such a large distance? I believe, I think I may divulge later in my opening segment, but would it be possible that it was too large and you may have at initial contact, misread what the speed was?
No.
Okay. That is all the question I have. Thank you, Officer Gafford.
Yes, sir.
Okay. Anything further, Mr. Rosales? Any other questions?
I do not have any further questions. Thank
Okay.
you.
Mr. Connor, redirect.
Judge, I have no further.
Pardon me, I couldn't hear you, Mr. Connor.
No, I have no more questions, Judge.
Okay. You may call your next witness.
I have no further witnesses. Will stay with rest at this time.
Okay, state rest. Okay. Mr. Rosales, the state has rested. At this time, if you want to make an opening statement, you can go ahead and proceed. Would you like to make an opening statement, sir?
Yes, Your Honor. I would like
Go
to.
ahead.
So, Your Honor, today we are discussing the matter that occurred on the 25th day of January at around 12:40 noon. During that day, Your Honor, I had just gone off to school and I was tending to a small.
Okay, Mr. Rosales, and let me just stop you right there. You're not testifying yet. You know, an opening statement is just a brief statement that's going to tell the court what you think the evidence is going to show. Would you like to make an opening statement?
Yes, Your Honor.
Okay, go ahead. You may continue.
Thank you for helping me there. Okay, Your Honor. So based on the evidence that we have here, in order to determine whether or not a citation or traffic citation should be valid, it must be based on a burden of beyond evidence that shows beyond a reasonable doubt that the traffic violation was committed. And in this circumstance, I believe that that burden was not met because there is a reasonable doubt under the evidence and under my testimony that indicates that the citation may have been invalid and may have been unlawfully cited. In the alternative, Your Honor, I would also like to show that even if it was found that there was sufficient evidence to make a citation for speeding, Your Honor, that at the moment, the speed from which I was clocked was reasonable and prudent under the circumstances. Based on the idea of the circumstances involving the exit ramp and the close proximity of the exit ramp to the speed limit sign.
Okay. So now, having made your opening statement, would you like to call your first witness? Do you have any witnesses?
I do not.
Okay, so I just want to make sure you don't want to testify, and then again, you don't have to testify. Would you like to testify before we go to closing arguments?
Yes, Your Honor, I would like to testify.
Okay, so you understand that you have the right of that I explained to you, your privilege against self-incrimination, that you don't have to testify, and then if you don't testify, it cannot be used against you as evidence in this case. You understand that?
Yes, Your Honor.
And knowing and understanding that, you want to waive that Fifth Amendment right and go ahead and you want to testify, correct, sir?
Yes, Your Honor.
Okay, if you could please raise your right hand and let me swear you in. Do you solemnly swear or affirm that the testimony that you're about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor, I do.
Okay, if you could, you can go ahead and give me a narrative as to what you want the court to know about this. And remember, this is the time to tell your story. So
Okay.
you can give me a narrative. You don't have to ask yourself a question and then answer it. You can just provide us with a narrative and you may proceed. If you could please state your name and your date of birth before you go on with your narrative.
Yes, Your Honor. Your Honor, I am Kevin Rosales, and my date of birth is on October 4th, 1994. And this is my testimony on the events that occurred on the relevant case. Your Honor, at the moment, before I got to the exit in Quaker, where eventually the citation was received, I was driving northwestward on South Loop and was in the process of going to go help a friend jumpstart a car. And I was exiting Quaker, and at the moment, as to my knowledge, my best knowledge, to what I know, that I was traveling at about 65 miles per hour before I got to the exit, which is the lawful speed limit there on the loop. And as soon as I was exiting, I let my foot off the gas completely. Now, while amidst the exit, not even getting to the end of the exit into the access road, I did notice Officer Gafford located on the Vale Street, which he seemed really close to the end of that exit ramp. Now, before I got to the end of the exit ramp, it is to my knowledge and recollection that being in between there, I saw Officer Gafford turn on his lights and initiate the process to pull me over. So it is to my knowledge and recognition that potentially officer did so before I arrived to the 45 mile per hour signal in the process. And so obviously abiding by the law, I slowed down continuously more and was ready to pull over up to a point to where I pulled over near a hotel down the road, and where the officer ultimately gave me the citation. Now, I did have a few exhibits that I'd like to present regarding the whole situation to help show what had gone on. Now, I'm about to share here. I have it on my phone. That's why I have two Kevin Rosales, is I have one to be able to share the exhibit.
And Judge, just to clarify for the record, I've not been provided with any of these exhibits, so I'm unable at this time to make a legal objection or determine whether or not these should be published.
Okay. Mr. Rosales, you can go ahead and testify, lay your foundation, and we'll see if the court admits them.
Okay, thank you. While in the process of turning this on.
Just give me the packet.
One moment, Your Honor. It seems I have some issues trying to share the screen.
We're all having issues right now with Zoom, so
Yes, sir.
we're patient.
Okay. Now, can you see? Okay, there we go. It seems to be occurring. Now, can you see a screen of pictures and whatnot?
Yes. Mr.
Okay.
Connor, can you see that?
I can, Judge.
Okay.
Good
You
to
may
know.
proceed.
Okay, so just to give an overview and more understanding of the process, here are a few pictures regarding the relevant location.
Okay, is that going to be your first exhibit?
Yes, this is Exhibit 1.
Okay, so let's mark that Defendants Exhibit 1. Okay, you may go ahead.
Perfect. Now, as you can see, due to this Google map area, you can see the beginning of the exit somewhere around this area, right nearby the arrow that went up. And it proceeds, continue on past this small street here, which is Vale, which I will have indicated in another exhibit. And towards the end of this Vale, which is this street, this pin right here, shortly after that is, before, to my best of my knowledge, is where the posted limit is. And as you can see further down, just a block down, is where Officer Gafford claimed to be, in which I also saw him here in Troy Street. And so he would be pointing down towards this street and pointing me down. And that's about 0.3 mile of a distance from the initial exit all the way down to over here, okay? And let me show you Exhibit 2, and this is where the Vale Street intersection is, as indicated before. This is before we get to Troy. That's only about 0.1 miles from even before the exit over here. So you can see the exit more clearly in this area. And I believe the exit ramp starts even a few more feet to the left of this indicator, down over towards this way. And Vale is the street where I think a little bit to the left, you have the indication of the speed limit, which is the 45-mile-per-hour zone. So that is a few meters of space to be able to slow down. Furthermore, here's another picture of that. This is Exhibit 3, showing the same almost the same output as Exhibit 2. Now here is Exhibit 4, which indicates that the distance between, I can't seem find the streets there. Let us not consider this exhibit 4. Let us strike this one.
So you don't want us to consider, or you're not going to show Defendants Exhibit 4, correct?
No exhibit for you.
No, okay. Go ahead.
Just for the sake of the record, this is exhibit 4, I guess now, since we're labeling. This is the Best Western in which I was pulled over. And then,
So that's your Exhibit 4, Defendants Exhibit 4.
yes,
Okay. You may proceed.
this is exhibit 5, which is a closer input of where the exit ultimately ends. Indicate from the ramp, just for visual effect. This will not be used. My apologies. And this overall is the general vicinity of all the streets that are nearby.
So,
Exhibit
so
5.
that would be Defendants Exhibit 6?
5, I believe.
5, okay.
Okay, now let me go back to some pictures that I took.
And Judge, I'm going to object to any of the pictures being published without the proper predicate being laid.
I'm going to sustain your objection. So, Mr. Rosales, you may continue, but again, you need to lay the proper predicate.
So can you explain by what you mean by the proper predicate?
You have to lay the proper foundation for the pictures or charts or whatever you need to introduce.
Okay, yes, Your Honor. Okay, let me access this. So this is not at the current intersection. This is an example of another exit ramp.
Judge, I'm going to renew my objection. These are being published to the court without any proper predicate, and it's in violation of the rules of evidence.
Okay. Response, Mr. Rosales.
Your Honor, these exhibits are being used to indicate and give a better understanding of the case that will indicate the possibility that Officer Gafford may have shot his laser before I got to the 40-mile-per-hour zone. And also,
Okay. But what Mr. Connor is alluding to is you laying the proper predicate for the court to be able to consider that.
basically the relevance, right?
More than the relevance, it's laying the proper predicate as to the proper foundation on those pictures. And again, I can't really counsel you on that because I'm here as a judge. And
yeah, my apologies. I haven't taken the rules of evidence in law school yet. So I'm going this by
some of us have, and we still don't understand them, but go ahead.
Okay. So I honestly don't know what the predicate is. So I guess, I mean, if it's in regards to the validity of these pics, these are all taken by myself that have the
Okay, go ahead.
Okay, these are all taken by myself that were taken, that have storage information on the date and are relevant to the case at hand.
When were they taken, sir?
These pictures were taken on the day of, well, the screenshots were taken both on the day of the citation. I came back around to make sure that we gathered some type of evidence of the situation. And, but also the screenshots were also taken. Screenshots and the photos were taken both on the same day. And I'm able to provide the picture profiles that indicate the time that they were taken.
Okay. Mr. Connor, response.
Still no testimony as to true and accurate depiction of the events as they existed, Judge.
Okay. Mr. Rosales, response.
Yes, Your Honor. This seems to be Is in fact a proper, accurate description of the circumstances due to the fact of having a reliable source such as Google Maps to determine the distance between, and the basic layout, which provides a satellite depiction of the roads, and the pictures themselves provide that are unadjusted, completely in their natural form of the surrounding areas of the events of the citation.
And who were they taken by?
They were taken by myself, Your Honor.
Okay, Mr. Connor?
Judge, we kind of commingled some things in there. I think we've hashed out that maybe the photos are true and accurate depictions maybe of close to the location as it was. At that point, if that is the case, the predicate's been laid, I wouldn't object. When we get back to the items 1 through 5, I believe on Google, the state would not object as far as demonstrative, as far as the Google Maps goes. But as the court's well aware, and Mr. Rosales will learn in law school, just because it says it on Google does not mean it's true. And without having an expert or somebody to authenticate, to come in, there's no way we can take for gospel that the measurements or the mileage or anything is that. And so as far as those go, we would not object as far as demonstrative, but we will object as to any kind of expert as to distances or measurements.
Okay. Defendants Exhibit 1 through 5, which I think are the Google Maps. Is
Yes,
that correct, Mr. Rosales?
Yes, Your Honor, that's correct.
Okay, they're gonna be, I'm gonna admit them as demonstrative evidence only.
Okay,
Okay.
that's
As to the pictures, and you're gonna have to go through them again, and you've laid the proper predicate, but I need to make sure that we have the record on the pictures being Defendants Exhibit 6, 7, or whatever, and those are gonna be admitted. If you can go through the pictures again, please.
Yes, Your Honor, I will. Allow me to go back into this. Now, can y'all still see?
We don't have, we see you right now on the screen.
There we go. Okay.
Judge, my other question is going to be, as far as these pictures, is if there is going to be a hard copy presented to the court for the file?
I am going to require everybody, Mr. Connor, you with the thumb drive for the video, and Mr. Rosales, I am going to require all of you to give me hard copies of the exhibits that have been admitted. And that way I can have them for appeal purposes, and also for me to evaluate and decide the case properly. Okay?
Yes, Your Honor.
So, Mr. Rosales, go ahead with the pictures.
Okay, yes, Your Honor, here we go. So I'd first like to provide, let me scroll through right away. So here we have the relative.
Okay, first of all, that's going to be Defendants Exhibit 6.
That's correct, yes, Your Honor.
Okay, proceed, please.
Here, Your Honor, we have the exit. Before the actual exit, it's the indication that it's coming up. So if we zoom in here, there is the Erskine Quaker Texas Tech Parkway exit. Further down, you can see the exit sign that would start to the exit. So that's Exhibit 6. It's more demonstrative in nature.
Okay, and now you're zooming in and out of that photo. And the photo that you're going to give the court, is it going to depict exactly what you testified to?
It will be able to depict that.
Okay, and go ahead and continue, sir.
Yes, Your Honor. And then let me access the next photo. That is the same, disregard that. I will label it soon. Okay, so here we have
that's going to be Defendants Exhibit
7.
number 7.
Yes, Your Honor.
Okay, go ahead.
So in this exhibit, Your Honor, we have a close-up of the exit of Quaker from when it was taken, and you can see the ramp itself going down this way. And further down, Your Honor, you're able to see towards the end of the exit where the speed limit sign is indicated right there to the left-hand side. It's not very clear, Your Honor, but I do apologize for that. But there is an indication of that. So it's almost immediately after the white line ends on this area here to where the postage is at. That's Exhibit 7. Here, Your Honor, is a clear view of as Exhibit 8. It's a clearer view further down from the exit that shows the posted speed limit.
Okay. Mr. Rosales, if I can just stop you for a second, make sure that when you bring me the hard copies, and can you get them to me by tomorrow, close of business, by 5 o'clock tomorrow?
Yes, Your Honor, definitely.
Okay. Make sure that each of the exhibits is labeled. Okay. So make sure you put a tag or something stating Defendants Exhibit 1, 2, 3, whatever. And that way we're able to identify them again for appeal purposes.
Yes, Your Honor, of course.
Okay, you may continue, sir.
Okay, so this being Exhibit 8, again shows further down the Quaker exit onto the access road. That shows the speed limit there of 45 miles per hour. As you can see, obviously I'm not an expert, but that is further down from this access road, from this exit ramp and the double line, a little bit further down. That's Exhibit 8. Wanted to find the next exhibit. Okay, Your Honor, this is Exhibit 9. Exhibit 9 demonstrates where Officer Gafford was on Troy Street, Troy Avenue, my correction. Showing down with the peripheral of the exit ramp of Quaker Street and with slight view of postage signs of where people exit and where this 45 mile per hour postage sign is at. This, Your Honor, is a view, Exhibit 10 from Vale Street, right next to the exit. Now, as you can tell there, that is right next to the exit, and it goes beyond the potentiality of the extent of the road. So with no sight, this could be used to demonstrate that there's no sight of the posted sign in this picture at the Vale Street. So just for indication. And those are the exhibits that I have, Your Honor.
Okay. You may continue then with your testimony.
Thank you, Your Honor. Hold on, let me stop this sharing right away.
Okay.
Perfect. So, Your Honor, it is my belief that under the current circumstances of that area, at the moment, while I was exiting from the exit towards the 45 mile per hour area, that Officer Gafford aimed his laser at me prematurely, and that he clocked me at a speed where I was almost barely reducing my speed from the freeway, and which would be an invalid aiming and therefore not a citation. And even if that's the case, due to the exhibits, I'd like to testify that the distance between the 65 mile per hour speed limit on the loop and to the 45 mile per hour speed limit on the access road is relatively small in order to decrease the speed. So it was reasonable for me to progressively slow down along that way, as I indicated, and I was caught a few times in the video. Your Honor, I believe, actually, I did have one more exhibit. I'm sorry for the improper procedure in this matter. Did you mind if I would address one more exhibit?
Okay, you go right ahead.
Mr. Honor. So this is Exhibit 11. Now, this is not close to the site of the citation, but this is just for reference of an exit that indicates before or on the ramp of the reduced speed limit or the change in speed limit. So
This is not the exit that you exited.
this is not an
Judge,
exit.
I would object to that as irrelevant and
Yeah,
immaterial.
and what is the relevancy of that, Mr. Rosales?
The relevancy of this, Your Honor, is to indicate that I was not given notice when I was exiting due to the other side. So on the other exit, it's comparison. So on one of the exhibits, it does show the exit itself, and there is no provision of this 45 mile per hour exit zone. So I will use that, Your Honor, to establish that I did not have notice until I actually arrived to the speed limit zone.
Okay, go ahead, Mr. Connor.
In judgment, I'm sorry, and in this case, notice is irrelevant because speeding is a general intent crime rather than specific intent crime. And the fact that the speed limit was 45 is proven. You can take judicial notice based on the city ordinance. It would not matter whether or not there was notice or not. And so it's irrelevant as to show anything between this location and any other location.
Okay, I'm gonna sustain the objection, Mr. Rosales, and you may continue.
Okay, Your Honor. Okay. I believe that is all the testimony I have at the moment.
Okay, anything else you would like to add?
I guess since we don't necessarily make our legal analysis at this point. Is that
No,
part?
and this is not closing argument, still your testimony.
Okay, sounds good. All right, no, that's it, Your Honor.
Okay, Mr. Connor, cross-exam?
Thank you, Judge. Mr. Rosales, how long have you lived in Lubbock?
I've been a resident for I've been here since undergrad, back and forth. So about 2013, so about 8 years.
Okay, and not that it's really relevant to anything, but I was doing the math when you gave your date of birth. You're a little older than normal law. Non-traditional, did you come about it non-traditional?
Yes, Your Honor, I plan to enter into law school, but we had some unforeseen family adversity that caused me to postpone.
That's fine. I was non-traditional too, and I appreciate that, and that's kind of why I caught on with it. So you went to undergraduate here too, correct?
Yes, Your Honor. Yes, sir.
And which and what year did you graduate undergrad?
2016.
Okay, so you've been here 2012, 2013, somewhere around that?
2013, since 2013 August, all the way up to.
Okay, so would you say that you've driven on the loop few or many times?
I've driven on the loop quite a few times.
Quite a few times. And so would that mean that you've driven on the access roads few or many times?
Yes, I've driven on access roads.
Okay, and what are the speed limits generally on the access roads?
From what I've noticed, speed limits are usually from 45 to 50 miles per hour around the.
Have you seen any where it's 61 miles an hour on access road?
I have not.
Okay. Now, when the video, you didn't watch it and it was choppy, and that's bad. And I apologize for that credit, but you continually ask for a break. You just need a break on this deal. And is there any reason you are doing that, like asking for a break? Or
I was asking it under the circumstances because I believe that it may have been a mistake to where he clocked me. So
okay. But that's not how you were acting. You were asking like, hey, give me a break, give me a warning on this one.
Basically, but that was based on that. And I did explain that some part of it, I did tell him that I was slowing down and
Okay.
I wasn't there. And it was just all in the moment. I was a little bit
Let me
flustered.
ask you this. How far, those pictures you showed, and I apologize for this too, it's rather disjointed when we're dealing with Zoom. It's hard to do. It's not the same as being in person. And I would be glad, I'd love to visit with you in person and talk about this before, after, or whatever. And I'm just telling you from having a lot of years of trial experience, this is kind of a difficult way to do it. But one of your exhibits, and I want to say it was like number 10, where you showed Vale Street. Can you kind of give me a guess as to how far Vale Street is from where the officer was sitting on Troy Street? Not, you don't have to review anything. Just kind of give me a guess about where that is.
Well, I mean, that's a block. I think it's a solid block from around there. And then between those two streets is where I remember seeing.
And do you know in general, like from your personal experience, do you know in general how long a city block is?
I do not, Your Honor.
Okay. Okay. So if I told you like some blocks are 400, some are 800, would that be strange to you? We're measuring feet, not meters, but would that be awkward or strange to you?
No, but I mean, can you repeat that question? Sorry.
So if I told you a city block generally was either 400 feet or 800 feet, would that be strange or awkward to you? Or would you agree that that's a reasonable distance for a block?
I'd say sometimes it depends on the blocks, but I mean, that kind of makes sense.
Okay. So if the officer said you were 300 feet away, that would mean you were further than Vale towards Troy, correct?
Can you repeat that and clarify that a little bit more?
Okay. If the officer said you were 300 feet away when he clocked you, that means you're past Vale and you're already headed towards Troy, correct? Because your testimony is
Possibly.
okay. All
That's
right.
right.
I don't have any further questions, Judge.
Okay. Mr. Rosales, anything else you'd like to add?
Oh, no, Your Honor. That's all I have.
Okay. Mr. Rosales, do you have any other witnesses you'd like to call?
No, Your Honor, I do not.
Okay, so you rest also.
Justice.
Okay. And
We close,
Mr.
Judge.
Connor, you
We
close?
close.
Okay. State closes. Pardon me. State closes and defendant closes. Okay, now I'm going to give you all an opportunity to give closing arguments. I'm going to allow a maximum of 10 minutes. Mr. Connor, as usual, you get the first 8 minutes, and then Mr. Rosales, you get the entire 10. And then Mr. Connor, you get to come back and do a maximum of 2 minutes afterwards. So Mr. Connor, you may proceed.
Judge, thank you. And you realize it will not take 8 minutes, and I'd be shocked if the other took 10, but here we have the case. Officer Gafford was operating his laser, traffic, everything that jives out with the defendant's evidence is exactly on point with the evidence that the defendant pointed. He was exiting the loop at miles per hour and got off the loop and was already well within 500 feet within the access road, not only on the access road, but past the signs when he was measured still at 61 miles an hour. It was the testimony of the defendant that he's drove many times around the loop and he knows the speed to be 45 to 50 miles an hour, and that in no way would it ever be proper or procedural to drive 61 miles an hour. You know, I pointed out earlier that it's specific general intent rather than specific intent. The speed is 45 and he was in excess of that. I would say based on the evidence that the state would ask that you find the defendant guilty, and we look forward to our further close.
Okay. Mr. Rosales, closing argument, sir.
Yes, Your Honor. So, in light of the facts and evidence that were presented here today, I have two bases to why this case should be dismissed. The first basis is based on the idea that there is insufficient and inadequate evidence to demonstrate that it is beyond a reasonable doubt that I received that the citation for speeding at the time was lawful, Your Honor. Now, as you know, the standard for the burden of proof is beyond a reasonable doubt, and beyond a reasonable doubt is determined by what a rational juror would infer from all the facts and circumstances to determine if there is a potential reasonable doubt that the crime in fact did not happen. So, Your Honor, in this instance, I believe that there is insufficient evidence due to the fact that the video was unclear and wasn't able to indicate when Officer Gafford pointed his laser at me and when he exactly clocked me at the violated speed, Your Honor. It is from my testimony, Your Honor, that can create a reasonable doubt that I saw him come after me before I got, right after I exited the exit ramp. So that would be a premature, premature aiming of the laser gun that would calculate a premature speed that would therefore not leave the citation lawful for going 61 on the 45, Your Honor. Now, that is also based on the idea that on the exit, the 45 mile per hour postage sign is further down. So I did not know what the speed limit was, even though I'm aware that generally around the city it's 45 to 50, to be able to give me an opportunity to slow down. I know generally traffic violations are strict liability crimes, but at the same issuance, we need some type of information in order to be able to abide by the law, which I do often seek to abide by the law, as shown by my driving record and not having received a citation for 2 years and more, Your Honor. So, Your Honor, based on the reasonable doubt that my testimony conflicting with the testimony of the officer, Your Honor, I believe that there is insufficient evidence to prove beyond a reasonable doubt, because there is a reasonable doubt that the officer may have aimed his laser prematurely and gotten incorrect speed, Your Honor. On the alternative, Your Honor, I plead the court to dismiss the case based on the argument that if it is found by some means that I was traveling 61, in the alternative, I do plead that my driving was reasonable and prudent in light of the circumstances, even though there's a prima facie indication that it wasn't under the statute, which is, my apologies. One moment, Your Honor, I'm having a few difficulties accessing this.
That's okay. You go ahead.
Okay, sorry, Your Honor. Even though the prima facie speed limits indicating prima facie violation of the speed limit in section 545.352 in the Transportation Code, Your Honor, I believe that I was driving within a reasonable and prudent speed due to the circumstances in which, when I was exiting the street, Your Honor, I was driving at illegal speed and on the freeway, and upon exiting, it is my testimony that I was slowing down, and it is my testimony that the distance between the exit ramp, which provides no indication of the speed limit, and the actual postage sign of the speed limit of 45 miles per hour is insufficient to be able to recognize that the speed has reduced, even though my apologies, let me rephrase that. The distance between the exit and the 45 mile per hour sign on the said street makes it difficult and unreasonable to be able to adjust your speed accordingly, even though I was slowing down, which as indicated by the prosecutor, that I do generally know what the speed limits are when it comes to exits. I was slowing down for that reason. And I didn't know that it was going to be 45 miles per hour because it was far down the road, since I wasn't able to adjust my speed accordingly to be able to abide by the law. And more importantly, I think it is rather dangerous to be able to reduce your speed from 65 to 45 miles per hour within the small distance that there is between the freeway and that first postage sign right upon the exit. This is why in other cases in which the exhibit, even though it was objected to, they have an indication of warning of 45 mile per hour exits so that you may know and have notice of the law, Your Honor. So it is based on these two precedents, Your Honor, on the fact that there is insufficient evidence to prove beyond a reasonable doubt that the traffic citation was lawful, and based on the fact that my driving and my speed was reasonable and prudent under the circumstances, that I believe that this case should be dismissed, Your Honor.
Okay, anything further?
No, Your Honor, that's it.
Okay, Mr. Connor?
Judge, there was proof beyond a reasonable doubt, just on the testimony of the officer. The officer went above and beyond, explaining the laser. The courts took judicial notice the validity and reliability of the laser. What you didn't see in the video, and I invite you to watch when you are deliberating, is that the officer showed the gentleman the laser. Based on that, there just on that alone, there was proof beyond a reasonable doubt. The evidence that's presented by the defendant just cemented the proof beyond a reasonable doubt. The distances come into play. It was easy to see where it was 300 feet, 500 feet past the signs. As the defendant said, it is strict liability. It is general intent. His testimony is he knew it was 45 to 50. There's nowhere in Lubbock that an access road is 61. So I think on all points, all legs, all avenues, the defendant's argument fails. And based on that, we would ask that the court find the defendant guilty as charged.
Okay. Thank you so much. And I'm going to take it under advisement. I'm going to wait to look at the video. I'm going to wait to look at the exhibits that were introduced and admitted into evidence by Mr. Rosales. So if both of you can have the exhibits that I asked for in my office here at Municipal Court by 5 o'clock tomorrow, then I'll take a look at it. Then I'll render my decision after that. Anything further from the state?
No, Your Honor. And as far as punishment goes, we will surrender to the wisdom of the court as we generally do.
Okay, thank you. Anything further, Mr. Rosales?
I'm not sure if I'm able to add to a little bit, just one aspect. I guess it's part of the rebuttal, but am I still able to? I forgot to address one thing in my closing argument, if that's allowed.
What's that?
I wanted to ask if I could address one more thing from my closing argument, but I'm not sure if that's allowed, considering the fact that we're towards
Mr. Connor, do you have any objection to Mr. Rosales reopening?
I would object. He's closed his closing argument.
Okay. Mr. Rosales, I'm going to give you a minute to do it, okay?
Thank you, Your Honor.
Go ahead, sir.
So I'd further like to add, not as a rebuttal, but just to clarify and provide additional support for the circumstances on both of my arguments, argument 1 and 2, that it is the testimony of Officer Gafford that he had been aiming the laser at me before I even got to the exit ramp, as he knew that I allegedly was going 70 miles an hour when I know I was going 65. So he was aiming at before. So the fact that he was aiming at the entire time may give rise to the possibility that he may have miscalculated the speed or aimed at me and determined the speeding prematurely. So based on that idea, on both arguments, I mean, mostly on the first argument, that's a reasonable doubt that indicates that I may have not been speeding and that he prematurely aimed the laser at me to calculate my speed.
Okay, thank you. Mr. Connor, I gave him an opportunity, so let
Yeah,
me
Judge,
give
I
you,
would just point out that,
and you have a minute also, okay?
no, it won't take that long. I would just point out that whenever the officer locked in the speed, it also locked in the distance. And so there isn't no doubt at all that it was 300 feet away from the officer, 321 feet to be exact, away from the officer when the speed was locked in. So that just kills the argument of the defendant.
Okay, so again, I'm going to take it under advisement after I get the exhibits that y'all are bringing in by tomorrow at 5 o'clock. So we are adjourned and you may log off. Thank you all.
Thanks, Judge.
Thank you.
Have a good day, Mr. Rosales.
You too, sir.
Thanks, Josh.
Yes, sir. Thank you.
Thank you, officer. Okay,
Yes, sir.
do I just hit close?
Go ahead and go to stop. I think it'll do it, but just right click on